Yes. 22. So this has become instructed. Here for the petition. Yes. Mr. W. Raman appears on behalf of Mr. A. Sharma, learned counsel for the petitioner, while Mr. N.C. Das, learned senior counsel, assisted by Ms. J. Bhaishya, appears for the respondent number 2, 3, and 4. So, stop. Next para. The counsels for the parties both submit that the PF contribution payable by the respondents number 2 to 4 has been paid by the respondents, and accordingly, the writ petition can be closed. So, stop. They also submit. Now, Mr. N.C. Das has also submitted a letter dated 5/11/2024 issued by Additional PF Commissioner Board of Trustees, which is to the effect that the respondents number 2 to 4 have deposited the uh, which is to the effect that the petitioner has submitted the deposited PF contribution. The letter dated 5/11/2024 is made a part of the record and marked as an extra. In view of the submissions made by the counsel for the parties, the writ petition is closed as instructed. The interim order passed earlier stands vacated. It's okay. It's okay. Interim order passed. Stands vacated. Thank you. '23. Yeah, for the petitioner. Instructions were to be uh, who is for the other side? Okay, Mr. He said that no, Mr. B. Barwa, learned counsel for the petitioner, and Mr. B. Das appearing on behalf of the APTC. Here, the counsel for the APTC are given a week's time to obtain instruction. Accordingly, leave this matter after a week. Give a date. Or before? Okay, let's leave the matter on one track. Okay. Is there any stay order? No. Okay. Ah, okay, right. Mr. P. Bhardwaj for the IOCL submits that he had misplaced the file. However, the same has been, however, he will reconstruct the same for which he needs some time. The same is not objected to by Mr. D.J. Das for the petition. Accordingly, leave this matter after 2 weeks. We tell him order to continue till the next. New matter, old matter, what? Old matter. Monday. Okay. Huh? When is it? Okay, when? Huh? Okay, oh, those matters. But tomorrow we're full. Too many matters. Ah, Friday. Yes, what about it? So what is to be done? Electric connection has been given to you. Not electric, but you have got some huge areas to pay, I guess. Huh? And so when do you all want? I do not know. You all decide when do you all want. On the pair of the parties, list the matter on third. New, old, give after 14. Of correct. Unfortunately, when you if you're not here, what to do? We have to believe what they say. And your fault. No, 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 there's no question of that. Your fault. You should have sent some junior of yours or someone. Or you could have come. Were you in court yesterday? You could have come later in the day. Whole day, what were you doing? You were arguing in some court. Yes, yes. Yes. Ask you the date. You could have mentioned two or something. It's not, no, no, nothing doing. Nothing. No. We have got enough work on our hands. You give some time in after 14, that week after the 14. No, have where is your mentioned memo? Ah, no. Yes. Which one? Which one? This. Yes, Chamaria matters. Okay. Ah. Where is your list? Mention memos. No, no, you have got actually it's a new matters. Ah, list it. Ah, yes. Okay, tomorrow. It's a new matter. Old matter. So what do you want? When? Next week. Okay, Monday. New matter. Okay, right. Heard Mr. M. Data, learned counsel for the petitioner, who submits that the settlement of the fishery with the respondent number 5 had been set aside by this court in the order dated 23/9/2024, passed in WPC 4484 of 2020. However, the respondent number 5 is still continuing fishing with the knowledge of the with the knowledge of the respondent, state respondents. Issue notice, returnable in 4 weeks. Petitioner takes steps for service of notice upon the respondents by registered post with AD within 2 days. List the matter after 4. Heading 2. Not done. Okay, right. Heard Mr. A. Barwal, alert counsel for the petitioner, who submits that the direction passed by this court to the respondents to release the petitioner's excavator in terms of the order dated 30/09/24, passed in 14/36 of 2022, has not been complied with. Issue notice, same thing, huh? 4 weeks, 2 days. Okay, yes. Okay. Mr. S. Tamaria is present for the petitioner, while Ms. D. Jain appears for the Water Resource Department. Mr. S. S. Roy appears for respondent number 2. This matter tomorrow. Okay. Yes. Item number 3, 5, 6, 7, 9, 11, 12, 13, 14. Tomorrow, yeah, entire list is going to be yours only. No, different causes of action, different amounts. It will not be the same. You see, and in some cases, it can be admitted, in some cases, it might not be admitted. We do not know. It's okay, it doesn't matter. At least we'll have more disposals. Heard Miss Angana, counsel for the petitioner, who submits that the petitioner's contractual dues amounting to rupees 40,65,673 has not been paid. Issue notice returnable in 4 weeks. Ms. D. Jain accept notice on behalf of Water Resource Department, while Mr. S. S. Roy accept notice on behalf of respondent number 4. Mr. S. Data appears for respondent number 2. This is the matter after 4 weeks to enable the respondents to file their affidavits. No, I doubt. Let us see the division bench order. That is a wrong submission being made by you. Show me the division bench order. There is no observation made with regard to what you're saying just now. Liberty to approach the appropriate forum. That's all was given. Yeah? Then why are you Why are you putting words into the mouth of the division bench order when it is not there? Mr. Counsel, I do not know what has happened during the time. During the time, you might be talking about Earth, Mars, Venus. We do not know. Okay, that is not that is not an issue. The only thing that this court is concerned is what is written. You see, what has been written there. So you have got to stick to only what is there. We cannot decide what was in the minds of the court or you at that time. That is something to do with speculative thinking. Okay, you cannot speculate. So what was the division bench order? Yes, yes, you have only asked for withdrawal of the writ appeal to approach the appropriate forum. That's all. So did you approach the appropriate forum? Mr. Counsel, the writ petition has been disposed of by the single bench of Justice Surana. Now, once that has been disposed of, you filed a writ appeal against the order. You are unhappy with the order. But you withdrew your writ appeal without liberty being given to you to file afresh. Okay? Without liberty being given to you to file afresh. You are allowed to withdraw the writ appeal to approach the appropriate forum. Now, did you approach the appropriate forum? What is the new cause of action? Where is that? Where is that? So then no new cause of action. What new cause of action? Where is the amount? Come to your prayer. Your prayer is what? What is your prayer? Where is that 17 lakhs mentioned in page 41? Which is that demand which was challenged? Twenty-eight, Mr. Counsel, what are you trying to do? This is 2005. No, Mr. Counsel, please understand. In this 28/7/2005, what was the amount? Don't try to be too smart. Please just tell me. You come to Justice Surana's order. I think I'm going to might have to impose cost upon you. Anyway, just come. What was your prayer before in that court? I will call for the records, don't worry. It will come in a second. What was the prayer? Please do not lie. What was your prayer in WPC 3519? Give me that. All the files is here. What was your prayer? What was your prayer in 3519? What was the similar nature of prayer? Let me enlighten you. In para 23 of your writ petition in 3519, it is not here. You have, unfortunately, this is the second time where you have not given all the facts. You have said the petitioners were thus taking into account all the above facts into consideration, the petitioner prays before this honorable court to set aside the impugned demand notices dated 28/7/2005, by which the petitioners were illegally demanded a penalty of 12 lakhs 83,959 on account of alleged overloading. Now, that you have challenged that 28/7/2005, where 12 lakhs was demanded. Correct. Now, this writ petition has been disposed of on a with the by the learned by the coordinate bench, and which has attained finality because your writ appeal has been withdrawn by you. And then the authorities have decided, given you a chance to appear before them, and you have now this 12 lakhs has been upheld. Correct or not? As per page 41, please read. Has it been upheld or not? It has been upheld. Now, in this writ petitions, you are saying that there is a demand for rupees 17 lakhs. How do you get that? Mr. Counsel, please understand the question. Where is it stated in page 41 that you have to pay 17 lakhs? Where is it in the entire writ petition that you have got to pay 17 lakhs? Where else? That is your prayer. That is your prayer that you should not pay 17 lakhs. Where have they demanded 17 lakhs? Mr. Counsel, just show me 17 lakhs in your writ petition. Don't try to confuse the issue. The 2005 matters, still you are fighting with me. Where is your 17 lakhs? Where is your 17 lakhs? Nothing else. I don't want anything. Sorry. You cannot you cannot put figures as you want. How much is the amount payable by him? Correct. You see, Mr. Counsel, 28 July 2005, you cannot make a challenge to that now. Look, Mr. Counsel, 28 July 2005 has been challenged by you in 3 writ petitions. In all of them, you have said that the amount as per the 28/7/2005 is 12 lakhs. How come today you have suddenly said 17 lakhs? I think correct. And in all your writ petitions, you have said that the 28/7/2005 amounts to 12 lakhs in all your writ petitions. Now, suddenly, how come you have come with the figure of 17 lakhs? Please give me that 2005. I think we'll dismiss it first. It's not the way to do cases. You're trying to confuse the. Yeah, you have been given. You can go to the division bench. Okay, next, right. Yeah, what is the name? Deerati. Heard Mr. Deerati, Learned Counsel for the petition. Who submits that the position of penalty amounting to rupees 17,65, 881, while demand notice is dated 13/7/2023, on account of penal under charges for overloading of goods in the railway wagons, should be set aside. Okay. Now tell me one thing before I continue with the judgment, with the order. In page 38, Turn to page 38. Come to number 3. You have asked for setting aside the order dated 13/7/23. Correct? And what about as well as demand notices? Again, you have asked for the demand notice setting aside. Correct? Correct. And 28 July 2005 also. So you say, by the amounting to Mr. Sir, by demand notice dated 13/7/23 and demand notice is dated 28/7/2005. Okay, comma on account of sale. Okay, right. These questions are fact. How is this court going to know? These are issues, right? Right. Okay, dismiss. I'll pass the order later. Everything, all people. Because how just all the file. SS Roy appears for. Okay. Okay. Oh, you just said, heard the so. Then order reserved. But it takes some time. Order reserved. Yes. Huh? Okay, heard Mr. S. Faulkner talking for the petitioner who submits that the petitioner being L1 in pursuance to the DNIT. DNIT? In pursuance to the NIT dated Feb 9, 2023, comma. The petitioner was issued letter of acceptance on 15/3/2024 by the PW. The petitioner had also furnished the performance security on 21/9/2024. However, no work order has been issued to the petitioner till date. Mr. B, huh? 21/8. You have written 21/9 here in your synopsis. 21/8/24. Mr. B. Gogoi shall obtain instructions as to why no work order has been issued to the petitioner. This is a matter on when. Give a date next week. Extra code. What is this case? You have applied for fair price shop. So, what is your prayer? Where is that page? 17. Page 17? Page 17. Page 17 is your prayer portion. No, where is the order? That is 21/8/24. Huh? Yes, page 42, yes. 43. What, by this order, what right of yours has been violated? No, please. So you are challenging page 42 and page 44. 43 is part of 42, Mr. Counsel. What is this page 44? You're challenging. So these private respondents, their fair price shops have been cancelled. And however, that cancellation order was vacated, was what? Was set aside. So, so the cancellation order was withdrawn, basically, was withdrawn. And so they have been allowed to run. Now, what right of yours has been violated? Have you been given any fair price shop? You have applied against this shop. If they consider you, that's a different thing. But that's you have got no right. No right. Dismiss. No right. When they right? What right? Just show me one thing. Just tell this court. What right of yours has been violated by restoring the fair price shop license of the private respondent? For both the shop. What do you mean for both the shop? The shop is yours. Whose shop is this? Is that license yours? Yeah, right. Right. Heard, mister. Yes, anything to say? Ah, correct. Maybe. You go and fight there. This case I'm discussing. Heard, Mr. Ayala, the counsel for the petition, who submits that the petitioner had applied for grant of a fair price shop license under the Assam Public Distribution of Articles Order 1982 on 23/5/2022, due to cancellation of the fair price shop licenses of the respondent numbers 6 and 7. The respondents number 6 and 7 thereafter submitted appeals to restore their licenses, which was allowed by speaking orders dated 20/08/2024 and 21/08/2024 issued by the District Commissioner, Kachar. The petitioner's counsel submits that whilst that the licenses of the respondents number 6 and 7 could not have been restored while the petitioner's application for grant of a FPS license was still pending before the respondent authority. He accordingly submits that the impugned speaking orders by which the FPS licenses of the respondents number 6 and 7 have been restored should be set aside. And the respondent should be directed to consider the application of the petitioner for grant of a retail license under the APDA Order 1980. Huh? Maybe. So that's what I've said. That's what I've just said. Didn't you hear me? Whatever it is, you see, I do not know what right of his has been violated. Is that right? Next. Mr. S.R. Barwa, learned counsel for the state respondent, submits that the petitioner's application for a license having not been granted by the state respondents even till today. There is no right that has accrued to the petitioner to challenge the restoration of the license that had been granted to the respondents number 6 and 7. If they accordingly submit that the writ petition should be satisfied. Next fact. The facts of the I've heard the counts for the party. The averments made in the writ petition clearly show that the respondents number 6 and 7 had been granted a retail license for running a fair price shop in terms of the APDA order of 1980. It is not the case of the petitioner that the initial grant of retail license for running a fair price shop to the respondents number 6 and 7 were arbitrary or was in violation of the law. Full stop. Where is there? Nothing is there. Huh? What? Mr. Counsel, this the 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 cancellation the as such the petitioner as the petitioner has not made any challenge to the initial grant of retail license to the respondents number 6 and 7, comma. The subsequent cancellation of the retail license and restoration of the same in relation in respect of with regard to the respondents number 6 and 7, cannot, in the view of this court, be violative of any fundamental or legal right of the petition. Next paragraph. In the case of Ayub Khan Pathan, Nur Khan Pathan, the Supreme Court has held as follows. The petitioner having never been granted a retail license for running a fair price shop, this court is of the view that no challenge can be made by the petitioner to the restoration of the retail license of the respondents number 6 and 7. When the initial grant of the same has not been put to trial. Accordingly, this court does not find any ground to exercise its discretion in the present case, or the writ petition is accordingly dismissed. Supplementary motion 42. Okay, this is for 12th. Listed on 12th. Huh? Okay, right. Third, Mr. B. Raman, counsel for the petitioner, who submits that the NIT dated 29/2024 for settlement of the Lahari Ghat bi-weekly market for the period 2024-2025 has been cancelled due to the impugned notification dated 29/6/2024. As a consequence of the same, the operation of the Lahari Ghat bi-weekly market has been entrusted to the earlier settlement holder in violation of section 105 and 109 bracket 6 of the Assam Panchayat Act 1994, as well as Rule 47 of the Assam Panchayat bracket financial rules, 2002. He submits that as this court has stated the impugned notification dated 29/6/2024 in WPC number 3632 of 2024, insofar as the Anchalik Panchayat has been allowed to run, has allowed the earlier settlement holders to run the market, the same interim order should be has no has allowed the Anchalik Panchayat to run the market and not the erstwhile settlement holder, a similar order should be passed in this. Mr. S. Datta, appearing for the PNRD, submits that similar matters have been listed for 12/7/2024. 12/11/2020. Full stop. Next. And this is matter on 12. So, 12. Right. In view of the fact that this court has passed interim orders directing the Anchalik Panchayat to run the market and also barred the Anchalik Panchayat from allowing the earlier settlement holders to run the market, the state respondents are directed to ensure that the respondent number 7 is not allowed to run the market for the month of November 2024, provided that the KIST money has not been submitted by the respondent number 7 as on date. Full stop. If the respondent number 7 has deposited the KIST money for the month of November 2024, the respondent number 7 shall run the market only for the month of November 2024 and not for any period thereafter. Thereafter, from December 2024, the Anchalik Panchayat shall run the market. Under section 105. Whatever, there has to be, you cannot have the Kamrup Anchalik Panchayat or some other 105. List the matter on 12/11. Okay. Your issue notice returnable in 1 week. Issue notice returnable in 1 week. Mr. S. Data accept notice on behalf of the PNRD, while Mr. S.R. Barwa accept notice on behalf of the point number 2. Petitioner to take step for service of notice upon the respondent number 7 by a registered post with any within the course of the day. Full stop. In addition to the above, the petitioner shall serve dusty notice upon the respondent number 7 within 5 days. Within 5 days. And file affidavit of service thereof. If not able, then he cannot. I have said subject to the condition. Please read. I cannot spoon feed you. Na. This is milk. This is water. Now you mix it in your mouth. You have it. I cannot say all that. You please understand. Otherwise, the orders will take forever. You have to read, understand. I said subject to the condition. Okay, right. Third, Mr. 8OD, learned counsel for the applicant to submit that the Commissioner Secretary to the Government of Assam, Finance and Taxation Department should be treated as respondent number 8. Mr. S. Datta for the PNRD Department and Mr. and Ms. Yudas, for respondent number 1, 1, 4, and 5. And Mr. H. Barwa for, and Mr. H. Barwa for being appearing for the respondent number for the Finance Department. Submit that. No. Finance cannot come now. What is that? You were going to impeach them now only. That is what we are dictating right now. Mr. S. Data appearing for PNRD Department, Mr. Yudas appearing for response number 1 for a fund. Submit that there was no objection to the application being allowed. Accordingly, so and so is implemented as point number 8. Applicant to submit a corrected copy of the cost title to the registry within a week. I is accordingly allowed and disposed of. Now in the main case, you write, in view of the order dated 6/11/2024, passed in IAC 3271 of 2024. The Commissioner Secretary to the Government of Assam, Finance Department is implemented as respondent number 8. Mr. H. Barwa appearing on behalf of Mr. B. Roy, accept notice on behalf of the respondent number 8. Then we have affidavit. When are you filing? What about you? And you also. Are you filing? They are all money, CD. And right. Extra copies you please provide. Mr. S. Data appearing for the PNRD, Ms. Yudas appearing for respondents number 1, 4, and 5, and Mr. H. Barwa for respondent number 8 are granted 3 weeks time to file the affidavit. 4 weeks. 4 weeks time to file that. This is a matter of the 4 weeks. No, so in item 17, in 17, it will be respondent number 7. And in 18, it will be respondent number 6. Okay, but then but Miss Yudas in all. Okay. 19 is different. For 19. Yes, Mr. B.C. Bujari, learned counsel for the applicant, submits that Please show me this. You don't? Okay. Submits that. Uh, Mr. Akash Deep, IAS, Principal Secretary, Bodoland Territorial Council, Bodofa. It's here. Should be treated as respondent number 3. Miss, who's for the BTC? Miss Bora, right? Just in time. Miss R.B. Bora, except not Miss R.B. Bora, sub appearing for the no. This is a contempt. Okay, no need. That's right. The prayer of the petitioner's counsel is allowed. Applicant's counsel is allowed. So repeated as point number 3. Huh? Applicant to submit a corrected copy of the cost title with the registry within a week. I is accordingly allowed and disposed of. Then in the main case, you write in view of the order dated 6/11/2024 passed in IA Civil 3299 of 2024. Mr. Akashji is represented as point number 3. Issue notice to the respondent number 3. Petitioner to take steps for service of notice upon the respondent number 3 by registered post within 3 days. This is the matter after full. Yes. No, did not say. Give me the other. You see, I think you have to withdraw this 3302 because Mr. Akashdeep is already a party pleaded in this IS Civil 2581. See this, just showing this. So you withdraw already pleaded. And you were supposed to take steps for this respondent number 3 and 4. Is it as per this 3 and 4? One is Mr. Akashdeep, and then there is another person also. So you have got to take steps. You have not taken steps. Okay. Mr. B.C. Moshari, learned counsel for the applicant, prays that he may be allowed to withdraw the writ petition, the application. Inasmuch as Mr. Akash Deep, Principal Secretary BTC, has already been implemented in IAC 2581 of 2023, right order dated 12/10/2020. The prayer of the applicant's counsel is allowed. The IA is accordingly dismissed as withdrawn. Okay. Then you come to the main contempt case. Mr. B.C. Mushari, counsel for the petitioner, submits that he will take steps for service of notice upon the respondents number 3 and 4 within 3 days in terms of the order dated 12/10/2020. This is the matter of the full. Where is the report? Not made. So it's not a report then, it's as a prayer for time. How much time? Huh? This order was passed on 19/9/24. Okay. Okay, we'll give you some time. Let them clarify. Okay, Miss Yudas appearing for. Acha, for the circle officer. You make him a party in anticipation because he's going to make a report and you might want to challenge that report. Okay, we'll wait for the report. Okay, we'll wait for the report. Okay, Miss Miss Yudas uh, uh, submits that in terms of the order dated 19/9/2024, the circle officer was to submit a report whether any electricity pole had been erected over the petitioner's land or on public land. Full stop. However, the circle officer needs a further 3 weeks time. 3 weeks, 4 weeks time, 4 weeks time. Uh, uh, accordingly, on the prayer of Ms. Yudas, list the matter up to 4 weeks. Okay, this circle officer bracket Sonapur Revenue Circle bracket close. Uh, date you want required date? Give a date. Give a date. The other side is required. Who is the other side? BTC. Miss Arbi Bora has gone. Miss Mushari is there. Yes. Acha, one thing, you're not appearing. They're all avoiding now. Look, you see, there is this, we have got that list. You see from the list whether your name is there or not. Is your name there? Not there. In this list, it is not there. Now, what to do? This is a writ petition. Who is the counsel? Mr. B. Chowdhury was there. Call him. Yes. After some time. 27. What to do? Huh? Huh? Mr. N. Upadhyay is not here. He's not here. You wait. You call. 28 and 29. S.R. Raba was there. Huh? They are all doing the area. Okay. Yes, but it's what is this inquiry report that has been submitted? Let us see. Well, you tell them to produce that inquiry report. And what is this fresh inquiry? You produce the inquiry. Right. Heard Mr. G. Baishal and counsel for the petition. Mr. R.K. Mushari appears for the BTC and submit that an inquiry report had been submitted via letter memo number BTC/MISC/DNH-2/2023/13 dated 29/5/2024 by Shri Dithakananda Hazarika, ACS, Secretary BTC. However, the said the BTC authorities were not satisfied with the inquiry report and have now taken a decision to make another inquiry by an appropriate authority within a short period of time. He submits that the same is reflected in the letter number BTC/CD-79/2023-24/137 dated 5/11/2024 issued by the Secretary BTC. Mr. R.K. Mushari shall produce the inquiry report dated 29/5/2024 on the next day. List the matter on when? After 1 week. Okay. Huh? No, next week is too heavy. After that. 18? 18? Acha, this is in both. So both in both the both, huh? For both. Acha, it is, yeah, both the repeat. Separate. No, it's the common order. It's timing 27. That's what you said last time also. Huh? Finance is a party, yeah. Well, let us see your forwarding letter. 21/10/24. 21/10/24 it was sent. Yeah, forwarded on 29/10. And on 6/9 September, the order of this court is Mr. N. Upadhyay, then it's so submits that the proposal has been issued by the department to the finance department on 6/9. So your submissions are faster than the actions of your department. What is this? You're a counsel. You're supposed to assist the court. How did, huh? Very clear that it's a mistake. You're committing what? You're giving false submissions before this court. Yes, Mr. Gogoi, you're for the finance. You've got to take instructions. But it's 21/10 only actually, too short. But you're okay. Right. Mr. N. Upadhyay, Learned Standing Council Irrigation Department submits that the proposal for payment of the petitioner's contractual dues has been sent to the finance department by proposal number P-IRR-059 on 21/10/2022. Wide file number E-541065. He submits that the FS number is FS slash IRR dash and under, I was under, that dash should be down there. Okay. What do you call it? The 2024 dash 20 dash 25 bracket 1, then the under dash 653. Mr. B. Gogoi shall obtain instruction with regard to the proposal sent by the irrigation department. This is the matter. After 2 weeks, this is the matter.
Timing 24.
No affidavit for the last 2 years. That is what you paid for in August also. Then you paid for it in March also. Then you paid for it in, yeah. On March, you paid for it twice. Mr. B. Chaudhary, the standing counsel for the BTC, submits that he will definitely obtain instructions within a week as to why, as to the fate of the petitioner's claim for payment of contractual fee. To stop this part. This court finds that though the writ petition had been filed on 8/12/2022, no instructions have been received by the counsel for the BTC till today. In the event no instructions are forthcoming on the next day, consequences may follow. This is the matter on 18th.
13:30.
Next week, we are pretty full. But then only one thing I've got to explain as to whether the NIT that has been issued would only allow for the Samsung Electronics to participate in the tender. Yes, that is the main thing. Correct. So that means that there's no competition there. Among the, why don't you take it from the manufacturer then? Why take it from the dealer if you want the best price? Why? You see, it's so simple. You want the best price or you want to favor some particular dealer. I don't know. Why dealer? You take it from the manufacturer. Naturally, directly from the manufacturer. You don't have to go through a middleman. You procure it from whatever portal, but you have got to justify as to why it should be through a dealer when you want only a Samsung product. I don't know, it might not be a very easy case for you. Just think about it. Mr. B of Learned Council for the, okay, for the SSA. Submits that Parawise comments have been received and he will be filing affidavit within, within 3 days. Uh, this is the matter. When? Okay, submit that he'll be, no, just say Mr. B. Goyal, Learned Council for the SSA submits that he'll be filing affidavit in a position within, no, by Friday, what is that date? By 8. 8, by 8. Full stop. Are you filing anything? Are you filing any, then have you filing any reply? No. You're not filing. No, you're not filing. Only with Mr. Uh, P. Bhavik, Learned Counsel for the petitioner, submits that uh, on receiving the affidavit filed by the SSC, the respondents, the petitioners will file reply affidavit if required within 1 week. Accordingly, on the prayer of the party, clears the matter on 19th. Interim order to continue till the next day. Yes. Negative. No, why is this administrative approval not being given? Yes, why is it not being given? Mr. S. Data, Learned Counsel for 1 and 2, shall obtain instructions as to why administrative approval is not being granted, has not been granted till today. And he shall submit an affidavit positively within, yes, I've submitted, not say positively, shall submit affidavit within 2 weeks. This is the matter. When did you finish the contract work? When? 23. Okay, give it.
33 and 34.
Where is he? He was here. I think the government councils are too less or what? They're having a problem. So what is your submission? Where is that clause? No. This clause is what? It's in the NIT. Then where is that? Let us see. Show me. Are we disposing of the matter or not? Or what? Show me. Show me the NIT. The NIT is where is the NIT that you part? NIT dated 103. Yes, yes, yes. You have concluded. What? You have completed how much percent of the work? Entire. No, but the issue is with the okay. So okay. So and out here the work is 1.32 crore. If 20%, that means it's around 6.5 crore estimate. It'll be around 6.6 crore, I think. — 6.58 crores. So you have completed 164 crores worth, but it is a subcontract. No. What out here it says, for normal highway projects also, provided that at least one similar work of 20% of estimated cost can have been completed. So it doesn't mean that you have got to complete one entire contract work, not a part of a contract work. Okay, that's it. That's it. Okay. Of your earlier agreement. Okay, your earlier contract in Arunachal. Ah, ah. Okay, before that, now you submitted your tender. Your technical bid was disqualified. Page. Your technical bid was disqualified. Correct? I'm not, please let us not clutter up the issue. The issue is your technical bid for in this NIT has been cancelled. NIT dated 18/6/2024. Where is the cancellation or disqualification? Where is that? 178. Yes. That is for Rangya. And this one is for After 1 year. No. Approval letter given in 24. Yeah, subcontract was completed in 30 April 23, 24, 23. Then just a minute. Who has issued? Who has issued? Approval has to be taken 15 days, within 15 days. Oh. Where is this page 11? This 4.2, where is it in your contract agreement or in the tender notice? Where is it? This is with in another contract agreement. Just a minute. What does it say? It says the contractor, whether joint venture or so, shall not subcontract any work more than 49%. Effective directly on Where is that rejection? That page 180. Rejection of your technical bid. They have taken action under which provision? They have taken action, disqualified your technical bid under which provision of the NIT? I'm not asking you that, Mr. Patel. Please. 2.2.2. Say that. That's what I want. I don't want anything else. Otherwise, you'll try to explain too much, even I get confused. Yes, Mr. Bhavai. Yes. Hmm. Yes. No, where are you reading? It says this P221 is a letter dated 27 September. A chart, yes. Name of work. Yes. No, where is approval of something? There's no approval of something. Approval of something. Yes. Hmm. 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 Yes. So now what to do? Then you authenticate and you find out whether this document at page 70 would cover the time period as on 11/8/2023. Correct, as on 11/8/2023. So you find out as on 11/8/2020. Page 72. Where was that? In progress. So it is not completed. But then this page 222 at page 103, 2.212 says that if more than 90% of the value of the work has been completed. So a work will be deemed to be completed if 90% of the work is completed. So again, they'll have to clarify. Because NIT last date of submission was what? So he must have completed on last 24th. Ah, correct. But then that is not the, so that is why I want to know the reason why he has been dismissed. You see, there are two aspects to this. What is the what is the what is the reason for disqualification? That has to be clarified. Because if it is only on account of approval not being given, then the petitioner has a case. Provided of course that there are further clarifications with regard to the completion of 90% of the contract work as on the last date of submission of the tender. Secondly, if the issue is with regard to uh, uh, whether the contractor would have to complete the work, whether as a subcontractor or not, but had completed at least 90% of the work, as even as a subcontractor, then maybe petitioner has got no case because he completed only 49% of the work. So that has to be clarified. But then that is why that letter at page 103 or no, 180 is not very clear. The 180, the bidder says so. This is a minute. That's what. So what is the ground of rejection? Just a minute, Mr. Kaur. Just a minute. Right. Uh, no. You see, it's not that. The issue is completion of the contract. Supposing the subcontractor does 90% of the work, that amounts to completion of the work. Then he comes in. The issue is whether a subcontractor who has done only 49% of the work, whether the amount is 30,000 or 40,000 crores, that's not the issue. If he, whether he, if he has done only 49% of the work, would he come under the, would he come under, would he be eligible under 2.2.2? And would that amount to say that he has completed the work? Because at the end of the day, he has completed only 49% of the work. That is not the case. There is nothing being clarified there in technical bid evaluation thing. No, okay. That way, so no, that way, so you come within that. That is all right. No, but the issue is this. It says that provided that at least one similar work of 20% of estimated cost price shall have been completed from the eligible projects. Provided at least one similar work of 20% of estimated. When did you complete? When did you complete? When was the project completed? April 23. The no, the entire because it says that for this purpose, a project shall be considered to be completed if more than 90% of the value of the work has been completed. So when was the project the contract work completed? People work. Right. Heard the councils for the parties. They shall the NIT dated 18/6/2020. The last date for submission of bids in terms of the NIT dated 18/6/2024 was 20/07/2024. No. You have to stand on your own leg. Anyway, right. Clause 2.2. Clause 2.2.2.2. Four twos, huh? of the NIT at page 103. Provides as follows, huh? Take it down from clause 2.2.2.2 bracket Roman 2 small. Provides as follows. This extract of clause 2.2.2.2 bracket Roman 2 small. Extract. Page 103. The next para, the party shall obtain instructions as to when the entire contract work that had been in which the petitioner had participated as a subcontractor and completed 49% of the work in Arunachal Pradesh was completed. The the shall also obtain instructions as the exact reasons for disqualifying the petitioner's technical bill by the next day. That's all. List 27/4. And the last date of this bid was 20 July. 20. Okay, good, good. Then we'll see. No, I want to know what is the exact reasons for disqualifying your bid. Then the others, we cannot make a decision now. Where are they sitting? Two and seven. 217. Yes. Yes. No, 4.2 is of which article? Of this present NIT or of earlier? I'm talking about this. Okay, carry on reading. Whether the subcontract was completed by the subcontractor on 2034. Is it only because it appears only because of the approval not given? Huh, Mr. Gogoi? If that is the case, then what is there? Tomorrow is Thursday. Next Tuesday, we've got that bunch matters we've got. We have law, we are. Thirteen, no, 13. 13 also we have got. Friday we have got that fixed matter with all, with your AG and everyone. Okay, you get the instructions by Friday, let us see what happens. You have to on the prayer of Mr. B. Well is the matter they have to on.
13:35.
You put this there. There is an order passed by the full bench regarding 22 to 60. No, I'm talking about there's a full bench decision of this court regarding ex parte orders 2263, Article 226. 7 days time. Have you read the judgment? Have you participated in the fresh tender? Did you participate? The concept, please answer the question. I didn't ask you what you ate for breakfast today. I asked you, did you participate in the fresh NIT that was issued? Did that? That's what I'm asking you. That's what I'm asking you. I didn't ask you anything else. Yeah, yeah, I asked you that and you're saying fresh tender issue. I'm asking, did you participate in the fresh tender issue? Please understand the question. Let them file their thing. 1 week, 1 week. Then we'll list on the next Monday or correct? True. Okay. We have got note. You see, we don't have time. That's what it- yeah. We don't mind disposing, but we don't have time. Okay, right. In the IA, with the IA. Mr. Elish Dhingia is granted a week's time to file a written objection to the application for vacating slash modifying the interim order dated 2/9/2020. Then that is the main case, huh? Mr. Elish Dhingia, learned counsel for the petition, and Mr. S. Chakravarti, learned counsel for the respondent. Submit that the matter may be listed on 18, on which date an attempt shall be made to dispose of the petition. This is the matter.
36 for order.
Huh? That they're going to cancel it. They have cancelled it or not? They have taken what? Huh. So what is to be done now? 2019 order is not work, there's nothing. Mr. Council, 2019 order. Why do you want to stay? We'll decide the entire matter. Huh? Okay, let us see a case. The main petition. Yes, yes, page 12. Yes, yes. Page 12, serial number 4. Yes, yes. No, no, tell me one thing. So they have cancelled it. So what happened? Were you provisionally selected or something? Ah, they complained me. Complaint with regard to what? Residential status. So the issue is whether he is a resident of that area. So is he a resident of that area? So where are the complaints submitted? Why are you not filing an affidavit? Have you filed any affidavit? Why don't you file an affidavit? Huh? Huh? There have been a order. Correct. Same here, even then, so that is what he's saying. In his case, there is no indication of Gaon Panchayat. And even in the case of 35, 36, 60, 60 and 61, there is no indication of Gaon Panchayat. How dare you have given them the retail outlet? Here you have not given. Okay. Yes. Yes. but there is no Gram Panchayat. Mr. Council, what is your name? What is the petitioner's name? Shrimati Ajanta Singh. Why have you said that, yeah, whether Gram Panchayat in which applicant resides the same as Gram Panchayat of the advertised location? Yes. Ah. So out here you have given 35, 36 you have given. Okay, you're the, Acha, you're the HPC, the Hindustan Petroleum. Huh? But serial number 3, the Gram Panchayat is there. Yes. Serial number 3, HPC, Kazimati, Moin Mata, Pathar, VCDC. Huh? This is written PCDC. So it is written VCDC. Where, anyway, how does it cause any prejudice if you want if uh, okay, who have who have given correct uh, okay, if who has given the correct who have mentioned what have they mentioned here in this Gram Panchayat? What have they mentioned? Could be- this priority list one. Ah, yes, okay, and in the priority list two, and what did they say with regard to this Gram Panchayat? So you see how many lists, how many priority lists can be there? Three priority lists. Okay. Where do we get this? Okay, okay, I get it. Hmm. Okay, okay, okay. Yes, that is why. So number two is eligible applicants residing in the concerned. So they, so can you bring the applications of the others priority list two and three? No, but they will come under. So they will not say Gaon Panchayat naturally because they are not under Gaon Panchayat. Yeah, they will come under subdivision. Okay, yes, yes, Mr. Council, no case. I think is not there. Then you come under. Then you'll have to probably come under subdivision. You see, you see when there is no Gaon Panchayat, you'll have to come under the subdivision. But you have said Gaon Panchayat. Correct. That is, they've got no case. Huh? No, you see, there are three things there. The first priority will be given to persons who are under the concerned Gaon Panchayat. Now, if you're not under the Gaon Panchayat, then the second priority will be given to the persons under concerned revenue subdivision. Then if those are not there, then the concerned Gram Panchayat. So you will come under subdivision. It is in your writ petition. It is in your writ petition. This is your writ petition, Mr. Counsel. There is nobody else. There's nothing. 2019 matter. Huh? Stay will all be vacated. Heard, Mr. A Borough Land Council for the petition. Also heard Mr. S. Bhattakur for the respondent for the Hindustan Petroleum Corporation bracket HPC. Mr. S. S. Roy appears for respondent number 1. The petitioner's case is that the petitioner had applied for appointment as an LPG distributor in pursuant to the advertisement dated 12/6/2018 under the HPC at the location Japorajan, Japoraja, under Bokajan subdivision in the district of Karbi Anglong under the open category. During scrutiny, the petitioner, no, not the petitioner was selected, was provisionally selected for grant of the LPG distributorship, following which the petitioner deposited the requisite fees. However, the Deputy General Manager, LPG, HPC, issued the impugned letter dated 17/4/2019, cancelling the advertisement for the location Japarajan only, with a direction to re-advertise the location with proper nomenclature and clarity. The petitioner's counsel submits that the petitioner is a resident of the area for which advertisement has been issued for grant of LPG distribution. He submits that there is no Gaon Panchayat in the said area, in the BTC area, in the Karbi Anglong Autonomous District Council. Correct? Autonomous District Council. Further, there is no Panchayat institution in the said district. He submits that when the extract copy of the advertisement regarding the location where LPG distributorship is to be allotted is seen, the same shows that there is no Gaon Panchayat in Japorajan area. He also submits that there is no Gaon Panchayat in the area under Umpani town, comma, Bok Chung bracket Gelapata, page 13, 35 and 36, and Siri Kindang and Moicham. Okay. Which are at serial number 35, 36, 60, and 61. He accordingly submits that when allotment of distributorship has been made in respect of serial numbers 35, 36, 60, and 61, where there are no Ghan Panchayat, the respondents could not have cancelled the advertisement and denied allotment of the distributorship, LPG distributorship, to the petitioner in terms of serial number 4, comma, that is Japorajan area. Next para. Mr. No, not continue. He accordingly submits that a direction should be issued to set aside the impugned order dated 17/4/2019 and to direct the respondent authorities to award the LPG distributorship in favor of the petitioner in respect of the Japarojan location. Next para. Mr. S. Bhattakur, the learned counsel for the HPC, on the other hand, submits that the allotment of LPG distributorship in the areas under serial number 35, 36, 60, and 61 can have no bearing on the award of LPG distributorship under serial number 4, inasmuch as serial number 35 is under the Bharat Petroleum Corporation, while serial number 36, 60, and 61 is under the Indian Oil Corporation. On the other hand, serial number 4 is under the HPC. The next paragraph. Mr. S. Bhattakur also submit that various complaints were received with regard to the applications submitted by the by the first priority of applicants, which included the petition. He submits that as per clause 15 bracket C of the guidelines as per the unified guidelines for selection of LPG distributors, there are 3 types of priority applicants to be considered for allotment of LPG distribution. The first priority consists of those applicants who are residing in the concerned Gram Panchayat, . area of the advertised location. The second priority candidate are those residing in the concerned revenue subdivision of the advertised location. The third priority candidate are those applicants not residing in the concerned Gram Panchayat or in the concerned Gram Panchayat area or in the concerned revenue subdivision of the advertised location. He submits that when there are no first priority candidate, then the second, then the allotment of the LPG distributorship is considered in respect of the second priority candidate. Thereafter, the opportunity of the third priority candidate are looked into when there are no first and second priority candidates. He submits that in the present case, there were 7 priority candidates who submitted their application pursuant to the advertisement dated 12/6/2018. Though there was no Gaon Panchayat in the Jagaram location, all the 7 priority candidates have in their application stated that, have indicated that they reside in the Gram Panchayat area of the advertised location. Instead, the first priority candidates, including the petitioner, should have indicated that they did not reside within the Gram Panchayat area of the advertised location, as there was no Gram Panchayat. As there was no, as there was no, as there was no, as there was no Gaon Panchayat, Gaon Panchayat. He accordingly submits that as there has been a mistake committed by the petitioner and the other 5 priority candidates. The respondents have taken a decision to re-advertise the same, which would enable the petitioners to participate in the new advertisement. This is for your good. In fact, if you have been cancelled, then the second party candidate would have got it. But it would not be for the benefit of the public. Actually, they could have done that because your application is wrong. Your application, those persons in the subdivision, those persons should have got it, not you. Yes, he'll be in trouble. No, not trouble. This has actually he's lucky that you all are doing it afresh. But I've said that. First stop. I have heard and learned causes for the part. A perusal of the extract of the advertisement shows that there is no Gan Panchayat in the Japorajan location. First stop. However, the petitioners have indicated in their application that they belong to the Gran Panchayat area where the Japurajan location has been advertised. This one. Thus, thus the petitioner has impliedly made a wrong statement. No, that has made a wrong statement and has put himself in the first category, first priority candidate. Put himself in the bracket of the first priority candidate by making a wrong statement. Should I make that? In as much as there is no in as much as it is not disputed that there is no Gaon Panchayat in the Japura Jan location. On considering the above, and considering the above fact, this court does not find any ground to interfere with the decision of the HPC to cancel the advertisement dated 12/6/2018 and issue a fresh advertisement for the Japura Jan location. According, this court does not find any ground to exercise its discretion in this case. The writ petitions accordingly dismissed. However, as and when the HPC issues a fresh advertisement for grant of LPG distributorship in the Japura Jan location, the petitioner should be allowed to participate in the said advertisement. The writ petitions accordingly dismissed. Review of the order passes the main case, the I is also accordingly dismissed. Aye. That's all. That okay, the security deposit. Huh? So yes, we have got to return that 10% of the. As in, okay, right. In that 136, it is fine. And respondents should return the 10% of the security deposit uh, to the petitioner, if not returned earlier. Hmm? Yes, Mr. Nair. Thirteen. So we'll list it next week. Found as serial number 7. Hmm? This is CC number 329. This is the one. To Devajit Shaikia, Senior Standing Counsel, BTC. With the reference and the name of petitioner is found at serial number 7. Correct. It is been by the AG, in fact. And it has been said that the entire amount will be paid. This is the letter from the Joint Secretary to the AG. Okay, right. Mr. P. Nayak, the answer for the point number 2 submits that payment of the payment to the payment will be made to the petitioner within 1 or 2 days. That is why you tell me how many have been paid as per the list. He is at serial number 7. Submits that the release of the outstanding contractual dues of the water resource department in the BTC area will start today. As the petitioner is at serial number 7. As the petitioner at serial number 7 in the consolidated list of contractors as per the letter dated 23/9/2024 issued by the Joint Secretary BTC to the Senior Standing Counsel BTC. This is the matter. Next. Tuesday. Continue.
1948.
Okay, instead of today, say within a day or two.
48.
Now, what to do? You can go to civil court. You see, if it's a false letter, now this is a writ petition. We can, I know this is the order was passed in the writ petition on the basis of the letter submitted by the E that there's no bills pending. Now, you are saying in the review petition, you are saying that the letter is a false document. Now, how do we prove that? You have got to prove your facts before the civil court. You go to the civil court. No. Where is the writ petition is for direction for payment. But when the respondents have taken a decision that there is no bills pending against the petitioner. Hmm? Pendency of contract petition. Contempt petition. There is a contempt petition. So that means there is a earlier writ petition. And what did the earlier writ petition say? Correct. So page 34 says what? Page 34 says directing the chief engineer to consider the representation for making outstanding payments. Correct. So it was not done. So you file a contempt. Now in the contempt, they come up with a letter saying that there is no outstanding bills pending. Then what would you want? Mr. Counsel, you will give you liberty to go to the thing, to the civil court. This is not a court where you can take evidence. This is a court of law, not a court on facts. Okay. So we cannot, right. Heard Mr. B. Fukan, Learned Counsel for the review petition, who submits that the order dated 22/7/2020 pass in WP in contempt case C 435/2021, comma, closing the contempt petition should be reviewed. So he submits that the contempt petition had been closed on the basis of the letter number PHE/M/G-51/2021/22/2722/24 dated 12/1/2022 issued by the executive engineer bracket PHE, comma, Morrigan Division, which was addressed to the chief engineer PHE Assam, PHE Water Assam, comma, Hengrabari, which stated that there was no outstanding bills pending in Morrigan in respect of the supply of ferric alum, FERRICALUM, by the petition. The letter also stated that the concerned SO bracket store and AEE bracket PHE, Morrigan subdivision had reported that there was no pending bill of the petition. Next paragraph. The review petitioner's counsel submits that the contents of the said letter dated 12/1/2022 issued by the executive engineer PHE Morrigan district is false. And as such, the review review of the order, impugned order dated 22/7/2024 passed with contempt case C 435/2021 should be allowed. The order dated the order dated 22/4/2019 passed in WPC 2552 of 2019 states as follows. Page 35, last paragraph, having regard to the, okay, till the end of it. Okay. Next paragraph. The order dated 22/4/2019 passed in WPC 2552/2019 not being complied with The petitioner filed contempt case bracket C 435/2021. So however, during the pendency of the contempt case, comma, the letter number so and so, PHE so and so, was dated so and so, was issued by the so and so, everything same, The contempt petition was accordingly closed. Next paragraph. Though the review petitioner's counsel submits that the letter dated 12/1/2022 issued by the executive engineer PHE Morrigan Division is false. This court is of the view that the issue of whether the contents of the said letter is false or not would have to be decided by taking evidence by taking evidence, and in that context, the appropriate court would be a civil court. Review of the above, this court does not. Now, further, this court is of the view that the ground for review taken by the petition does not come within the provisions of, it does not the grounds taken for review. Further, this court finds that there is no error or mistake on the face of the report for which a review can be allowed, only because the review petitioner is of the view that the impugned order, the letter issued by the PHE Morrigan district is false. Accordingly, this court is of the view that no grounds for review has been made out. The review is accordingly. Review petition is accordingly. I have said that. I have said that in the order. Appropriate court would be the civil court. You would. You can always apply at section 14 limitation act.
49.
Let him clarify. Yeah. Mr. B. Chakrabarti, learned counsel for BTC, submits that. No, Mr. B. Chaudhary, learned counsel for the BTC, submits that. Though he has received instruction, he needs further clarification. He accordingly prays for to file affidavit. Accordingly prays for 10 days time to file affidavit. Ms. Araboy appears for this point number 1. 1 and 2. You're filing anything? Yeah, 1 and 2. This is the matter. After 10 days.
40.
You have not submitted affidavit. Then okay. Mr. A.K. Sayawala, learned counsel for the petitioner, submit that the affidavit of justice service affected on the respondents number 3 and 4 will be filed within a week. Full stop. The office note indicates that notice by registered post with AD was sent to the respondents number 3 and 4 only on 23/10. Acha, you are for there. Oh, very good. Then no need. Okay, this right. Then Mr. A.K. Sayawala appears for the petitioner. Mr. A.K. Azad appears for the respondents number 3 and 4 and submits that he will file his affidavit within 2 weeks. Mr. S.S. Roy appearing for the respondents number 1 and 2. Are you filing anything? Submits that he is awaiting instructions. This is the matter after 2 weeks. What is this? Okay. So, okay. On, right. Huh? At the, no. He is basically saying that, okay, yes, at that, at the time of submission of your tender, did you have a MSA, were you registered with the MSME? MSME, 64, yeah, 24/11/20. Yes, yes. This is the work order. Okay, right. Next paragraph. On considering the fact that, no, let us go one by one to item 40 first. 41 we will see. 40, for 40. I am on 41 right now. 41 we will see. In for which item? 40, where? Yes. Oh, no, please come to 69. Page 69, item 40. Come at the bottom. Yes. And under Udyog. No, you'll be filing affidavit, but in the meantime, this matter is pending before the council. Before council. So till then, the council should not act. So because it will become infructuous with repetition if we direct repeat, then right on considering that the issue pertains to whether the respondent number 3 was registered as a MSc on the last date of submission of the tender. The operation of the impugned intimation dated 9/4/2024 issued by the respondent number 2 shall be stayed till the next returnability. List the matter on. After 2 weeks, 3 weeks, 2 weeks. After 2 weeks, 2 weeks. 22nd. And same kind of order in the next one. Same order.
10:43 for hearing.
Huh? Yes, so now, yeah, as per your affidavit, you have admitted to the fact that the weekly market is being run on the petitioner's land. Maybe, but now they don't want. So, no, they've got a right here also. Why should they go to some other court? There's no required. No, let us see your affidavit number 5. Let us see what is the affidavit of the respondent number 5? Affidavit of the respondent number 3 says what? So you see para 3. The market covers the government land 1.5 biga along the land of the petitioner. So this does not say the then
Not say how much land. Right, whatever that is there, but function is from them.
so then let us go item for then additional affidavit. That is the way. So what we can dispose of this writ petition. Wait, let us see affidavit of respondent number 5. What does he say? Okay, so you see there, now we can dispose of this case like this. Earlier, it was with your consent that the market was being run, correct? Now you don't want them to run. So we will tell them to demarcate your area within a certain time. And if the, and from a certain date, it has to be completed by a certain date. If it is, and from that certain date, the government will take a decision whether they want to use the land of the petitioners for a market, in which case they'll have to acquire it as per the Acquisition Act, 2013 Act. 2013 Act, no? 2013 Act, that's right to fair transparency and other stuff. And, otherwise you have to vacate the land. That's all. What is it? Heard Mr. S.I. Tarumdar, learned counsel for the petitioner. Also heard Mr. S. Datta, learned counsel for the Mr. S. Barua appears, S.R. Barua appears for respondent number 2 and 6. Next, you're right. This is order dated 13/2/2024, para 1, 2, 3. Oh, wait, para 1, 2, 3. No, no. No, 1, 2, 3. Okay, then, all right. Mr. S. Datta, the learned counsel for the respondents number 1, 3, 4, and 5. Submits that the Dupa Bara weekly market is being run by the Matya Anchalik Panchayat for almost 50 years. For the last 50 years, without objection from the landholders. Full stop. He submits that the bazaars are given by way of settlement through a tender process, and the petitioners cannot run the bazaar, the huts slash bazaar, the hut slash bazaar without the permission of the government. He further submits that the Matya Anchalik Panchayat has no interest in encroaching the land of the petitioners, and the weekly market can be shifted to government land without disturbing the land of the petition. He further submits that the Matya Anchalik Panchayat do not have the capacity to give any compensation to the petitioners for the land without approval of the state government. I have heard the learned causes for the past. The affidavits of the respondents number 3 and 5 gives rise to an inference that the Dupapara weekly market is being run by the Anchalik Panchayat on not only on government land, comma, but also on a portion of the lands of the petitioner, comma, without any objection from the landowner. Full stop. However, the petitioners are not willing to allow the respondents to run the weekly market on their lands any further. The affidavit filed by the respondent number 3 is to the effect that let's have this para is here. Second para of the second page of the order. So the biggest para. Next para. On considering the above facts, comma, this court is of the view that the is of the view that if the respondents are running a weekly market on the land of the petitioner, comma, they should immediately vacate the land of the petitioner. Full stop. In the event the respondents want to utilize the land of the petitioners for running the weekly market, comma, they should acquire the land of the petitioner in terms of the right to fair compensation and 2030. Right to fair compensation and transparency of the 2030. Within a period of three months from the date of within a period of 4 months from the date of receipt of a certified copy. Or take the land on lease from the petitioner by executing a lease deed, which is acceptable to both the parties. First stop. Next paragraph. The above directions are have to be made after the circle officer, Matya Revenue Circle. No, the respondent number 2, 4, and 6 make a verification slash survey report demarcating the land of the petitioners and coming to a finding as to whether the weekly market encroaches upon the petitioner. Actually, that's a demarcation. The verification slash demarcation report should be made by the respondents number 2, 4, and 6. With the 2 and 6. The 2 and 6. Don't say 2, 4, and 6. 2 and 6. Within a period of within a period of 1 month from the date of receipt of a certified copy of this order. Wherein they will, now which should be done after informing the petitioner the date of the verification to be done, to be made. Next paragraph. Next. Accordingly, this writ petition is disposed of with the following direction. Number one, the respondents number 2 and 6 shall cause a verification to be done, demarcating the land of the petitioners within a period of 1 month from the date of receipt of a certified copy of the sum. Number two, the respondent authorities. No, if the verification report, number two, if the verification report comes to a finding that no, after the verification report is made, a decision should be taken by the respondent number 2, 4, and 6. Correct? This is required. 2, 4, and 6 as to whether the land of the petitioner has. Okay, no, it's no with regard to encroachment. Okay, the respondent number 3 shall take a decision as to whether the land of the petitioner has been encroached by the running of the so weekly mark. So stop. Next paragraph. If now, which should be done within a period of 1 week from the date of the making of the verification report. Next paragraph. If the finding of the respondent number 3 is to the effect that the land of the petitioner has been encroached, lands of the petitioners have been encroached by the running of the so weekly market, comma. The respondent number 3 shall take a decision as to whether they want to continue utilizing the land of the petitioners. Full stop. Next paragraph. Next point. If the respondent number 3 comes to a decision that they want to continue utilizing the land of the petitioner, comma, they should either enter into a lease agreement with the petitioner on terms and conditions which are acceptable to both the parties, comma, or else the or else they should acquire the land of the petitioner in terms of the transfer 2039 within a period of that's all. Next, in the event the respondents are not willing to utilize the land of the petitioners any further for running the weekly market, comma, they should vacate the land of the petitioner. The entire exercise should be concluded within a period of 4 months from the date of receipt of a certified copy. The writ petition is accordingly disposed. No. You said 1 month. Okay, respondent number 3, make it 2 weeks. Okay. Yes, sir, please.